Swayam Prabha. Digital India. Educated India.
Welcome back to the second lecture in the course of Law of Torts, Consumer Protection and Motor Vehicles. Our second lecture topic title is Constituents of Torts. In the previous lecture, we saw the meaning and scope, the evolution, the definition and how torts is different from the other branches of law. Now, as I discussed in my previous lecture that there has never been an attempt to give other than a functional definition to law of torts, because it is not possible to give that kind of a comprehensive straitjacket definition. But what is important is that we need to know that what constitutes of law of tort, or what are the elements that constitute this branch of law called the law of torts. Now, there are uniform elements which constitutes this branch of law of torts, and in this second lecture we will discuss those uniform elements which go to constitute the law of torts. The four important topics that we will cover. The first three aspects are in connection to the constituting elements of law of torts. Now, in law of torts, usually we see that there has to be an act or omission, even in a negative way also, where you are asked to do something and you don't do, which causes some wrong or some kind of an injury. I will give you an example. Act means that I hit you with a piece of stone, that is an act. An omission is that I saw that there is a hole and the hole is not covered properly, and you can very well fall in that hole and get injured. I am supposed to call at my high volume pitch and ask, don't move forward because you will fall in the hole, but I don't do. So, that is not an act, but that is also something which can be constituting the wrongful act. So, an act in positive or sometime an act in negative which leads to some kind of an injury or damage is one of the constituents. The second constituent is that this act or omission which constitutes the wrongful act must be able to injure one of the legal rights. So, legal right means we saw that contractual rights are different from legal rights. So, there has to be some legal right, that is right which has been impliedly or expressly recognized by law, and that right or that legal principle is vested on that person and that is injured, and then this wrongful act injuring the legal right should lead to a possible palpable remedy or in form of actionable damages. If remedy cannot be provided or actionable damages cannot be provided, then also it is not coming within the scope of law of torts. Now, and the last topic is that whether we can have a generalized principle of law of torts, or torts should be kept like individual subjects or individual aspects, and each tort should be given its own sort of domain, own sort of working framework, and we should on that basis case to case as it arises we will say this is falling in this category of tort, this is falling in this category of tort, this is falling in that category of tort, like that. Or there should be a uniform. So, there is a some kind of a debate on this among the scholars and the commentators of law of torts. So, we will discuss that in our fourth topic. So, we start with this very first question: what constitutes tort? What are the constituting elements of torts? Now, Winfield very clearly says in his book that there are three principal constituting elements of torts. The first element is there must be a wrongful act committed by a person. So, there must be a wrongful act. Now, what is an act which is wrongful, and or all this we will discuss subsequently, but there has to be a wrongful act, and this act has to be committed by the defendant or the person who is now alleged to be the tortfeasor. Second, the wrongful act must give rise to an injury to a legal right. This is also very, very important. The wrongful act must not be an act which is not causing an injury, and it should cause a injury to a right which is recognized by law. Now, in this regard, there are two important maxims that has been operating in the field of law. One is called injuria sine damno, and second one is called damno sine injuria. In our subsequent discussion, we will see what is injuria sine damno and what is damno sine injuria, and some illustrations and examples. But as a general, let me tell you, injuria sine damno means that where a injury to a legal right has happened. Now, that injury may not cause a damage, but an injury has happened, and damno sine injuria means that damage has happened, but no consequential injury to legal right has happened. Now, you have to understand that where injury has happened, damage has happened, it is torts. Where injury has happened but damage has not happened, it is also torts. But where only damage has happened but no injury has happened, it is not torts. Even if there is a wrongful act, right, or wrongfully motivated act. Now, there are torts which are categorized as torts actionable per se. That means that there is no need to show that there is some damage caused or not caused. For example, trespass to property of others is a kind of a example where damage may not happen, but the trespass is enough. Say I have a long tree and whose overhanging branches have entered into the land of my neighbor, and now it is causing shade to the small plants which are in the garden of the neighbor from getting adequate sunlight, water, etc. Now, because of that, whether these small plants are dying, getting affected, diseased, or actually has died are not important. My overhanging branches have entered into his land, that is enough. So, that is called actionable per se. No proof of special damage is necessary. But there are some torts where damage is necessary. For example, negligence. Now, just claiming that my negligent act, there was an act of negligence is not enough. You have to also show that legal right was there, this legal right was violated by some wrongful act, and that act has now given, the violation of legal right by the act has given rise to some damage or some loss. So, therefore, actual damage is essential in some cases, actual damage is not essential in some cases, but violation of legal right is necessary. However, if there is only violation or only damage but no violation of legal right, then it is not coming within the ambit of law of torts. Now, that category of cases are called damno sine injuria. So, therefore, these two maxims we will discuss, injuria sine damno and damno sine injuria. And the third important essential constituent of tort is that wrongful act must be of such nature as to give rise to a legal remedy in the form of an actionable damage. Now, if your wrongful act causes an loss or injury to my legal right with or without a damage, it is fine. But if your wrongful act is something which does not cause or does not lead to a a damage which is actionable or damage which is possible to be given under the law of the time being, then in that case, unless a new tort can be developed, under the old tort system no remedy is possible. So, there cannot be a tort identified unless a new category of tort. In the last class, in the last lecture, I spoke about this example when I was trying to show that how Indian cases or Indian judges have kept the English law in mind, but not always directly applicable, and made modified changes, important distinguishing factors in order to introduce the law of tort or interpret the principles of law of tort. Now, I gave the example of strict liability in English rule versus absolute liability in Indian rule, M.C. Mehta case. Now, one step ahead we will discuss just now with the same case illustration, that when this case was filed by the plaintiff, his cause of action was in negligence or in nuisance or in trespass. So, he tried to use the law of negligence, law of nuisance, law of trespass. But unfortunately, in none of this category, except to limited extent in law of trespass, the case could be successful. However, it was clear to the court that if they leave this kind of a scenario unattended, it would be a grave injustice. And as I said, equity has always played an important part in decision making in torts. So, therefore, what the court tried to look into is that what else it can work out, if necessary a new tort can be established for the purpose of giving victims or the plaintiffs relief. Now, in this case, they evolved the new tort category of strict liability, right. So, there are several such examples that we will see where how new torts have been created, right. For example, another fine example that can work here is a new tort creation. A person came to meet his best friend's wife, and his best friend was a soldier who was at that point of time was fighting in a battlefield, and he was away from home. And this friend who came, he was also a soldier in the army, but for certain reason he was not at that point of time in the front. He was working from the office. Now, when he came to meet his wife, he tried to play a practical joke. What he said, that I got a message from the front today morning that your husband died. As a consequence of this news, though it was the attempt on the part of the defendant was nothing harmful, he did not thought it in that way, but he was just trying to prank. But the prank was such and the impact was such that the lady fainted and she was carrying, and there was a miscarriage, and finally the lady sued this person, saying that this is an assault. But the law of assault was not enough. There was no direct physical contact, etc., or this was a negligent act, second cause of action which was there also there was negligent misstatement was also not able to succeed. So, what finally the court tried to relieve is a new tort it developed called the tort of nervous shock. So, you can see therefore, sometime court do develop damages, to give damages or compensation new category. But in case where that is not possible, the court will not recognize the tort. So, these are the three therefore important constituents of tort. There must be a wrongful act. The wrongful act must give rise to an injury of a legal right, and wrongful act must be such that it give rise to a legal remedy in the form of an action for damages. Now, discussing in little detail, what is this wrongful act committed by a person? Now, an act complained of should under the circumstances be legally wrongful as regarded by the party complaining. It should not be an act which is not considered to be legally wrongful. For example, I am a justified voter, I have a voter I card, my name is in the roll, and I go to the polling station on the day of election to give my vote. But due to certain hurry or other reason, I forgot to carry any identity card with me. I am not carrying the voter I card, I am not carrying Aadhaar card, any other driving license identity card with me. Now, when I go to cast my vote, the polling officer asked me to show my identity card. Now, I told him that, see, I am coming from some 25 kilometers away and I am a eligible voter and I have forgot to bring the I card, and I card is not mandatory. You can see my name, you can verify my name, my address, you can ask me any questions, or you may ask even the people who are in this line, a lot of them know me that I am a resident of this area, allow me to cast my vote. Now, he does not allow me. He says, no, without identity card, I will not allow you to vote. So, finally, after lot of lot of verbal debate, I leave the place and I come back home. Now, this act which denied me, whether it is a lawful or an unlawful or a wrongful act, this is a wrongful act if the law does not say that unless without a voter I card a person cannot be allowed to cast vote, then, or it says even subject to certain condition, then if I am denied only because I am not carrying I card or I was not able to produce I card, is a wrongful act. So, therefore, an act complained or should under the circumstances be legally wrongful as regards the party complaining, that is must prejudicially. So, what is legally wrongful or when an act becomes legally wrongful? This is what makes an act legally wrongful, that is must prejudicially affect him in some legal right. The act prejudicially means wrongfully, illegally affects me, right. So, for example, there is a multi-storied building and I stay in the ground floor of the building. Now, there is a person who throw garbage from the 8th floor of the building. Now, the garbage bin is there, but that person does not come down and go to the garbage bin and drop it. He throws the plastic packet in which his garbage is accumulated and throws it from his flat in the 8th floor balcony of his flat to the garbage, attempts to kind of throw it, but sometime it falls in the garbage bin, sometime it falls on the ground, and all the obviously the bin coming down from the 8th floor hitting the ground will obviously break, and the moment the seal breaks open, all the garbage splashes all around, it causes fuel smell, animals like dogs, cats, rats, they come, to eat this waste. So they then scatter it. It's a cause of nuisance. Now this is where is prejudicially affecting me. Now he may say, you are inside your flat, I am not throwing in your flat. I am throwing the garbage bin in the garbage bin. Sometime it falls in the bin, sometime it falls close by to the bin. So why are you disturbed? But it is prejudicially disturbing me because the smell is disturbing me, the flies and the insects are disturbing me, the dogs that come are threatening my self and my family's peace and even physical security. So all this. So this is prejudicially affecting him, and this is affecting my legal right to peacefully reside in my place. So legal right to peacefully reside. Merely that it will, however, directly do him harm in his interest is not enough. So the last part says that it must prejudicially affect him in some legal right. Merely that it will, however, directly do him harm is not an interest to say that it is a wrongful or it is an act which is prejudicial. So merely some direct consequence of this will affect me, or something like it may be something in future affect me. All this is not enough. I have to show when I am complaining the act is wrongful that it will prejudicially affect me directly. So the illustrations that I have given. So therefore the crucial test in these cases to determine what is that wrongful act has been laid down by courts in various cases, and the test that is applied says that legally wrongful act or omission which is prejudicially affecting the legal right of another. So if you have done an act or you have omitted to do an act which both is directly prejudicially affecting the legal right of a person, then it is a wrongful act. And such a wrongful act is a constituent or the first constituent of law of torts. Now, when it comes to prejudicially affecting my legal rights, now legal rights are categorized usually in very broad number of groups, but we are just taking two most basic types of categories. There are different types of categorization of legal right. We are taking two very basic type of categories. One is called the private right, another is called the public right. Now what is private right and what is public right? Now private right is rights which belong to a particular person to exclusion of the world at large. So I have certain private rights, privacy. I have a right to live in my house secluded from the world. The four walls of my house are my castles and nobody has a right to enter into that without seeking approval or permission or by authority of law. Other than that, nobody has any business or nobody has any right to enter. But what is public right? Public right are those rights which are vesting on people at large. It is not a personal right, it is not an individual right, it is vesting on common members of the society. Right to walk in the society, right to walk in the roads without any fear or without any kind of sense of insecurity. So it is my public right to be protected from any sort of bodily injury, from any sort of antisocial activities, from any type of acts which cause any harm to me. So therefore criminal law, law of torts, they all operate to protect these public rights. The public rights are then categorized as constitutional rights, fundamental rights, etc., etc. Let us not go. So the basic two types, private rights and public rights, right. Now liability for tort arises therefore when the wrongful act complained or amounts either to an infringement of a legal private right or a breach of violation of a legal duty. So when your act is wrongful, your act is wrongful, as I said, the crucial test, if I go to my one slide back, the crucial test is that legal wrongful act or omission if it is prejudicially affecting on the legal right of another person. Okay? So, prejudicially affecting, that is important, and prejudicially affecting what? Legal right of another person. Now, we come to see that what is that legal right. Now, the courts have said that when it comes to legal right, liability for tort arises when the wrongful act complained of amounts either to an infringement of a legal private right or a breach or violation of a legal duty. Now, I will give two examples here. One is, I have a right to stay in my house peacefully. Now, if a person enters my house with an intention to breach my privacy, then that person has committed a violation of private right, infringement of a legal private right of mine, right. Now, so this is one category, when the act of entering into my house to commit violation of my privacy, which is a legally protected right, is a wrongful act. Second category is or a breach or violation of a legal duty. Now, if I look it from the defendant's perspective, the defendant is under a duty not to enter into somebody's house without his permission. Now, if he does that, he is what? A trespasser. So, therefore, trespassing as a tort means what? Breach of duty, of legally entrusted duty to not violate somebody's private right to property. So, a trespasser to property is a breach of this. Now, violation of legal duty, how it happens? Violation of legal duty is, say, a person is under a duty to produce goods when he is producer of goods which are very, very sensitive in nature. For example, medicine, chemical or toxic substances. So, he is under a legal duty to take utmost care and utmost caution in his manufacturing process. But instead, he somehow completes the work with negligence, and that causes a damage or injury. That is what? Violation of a legal duty. What is a legal duty? The legal duty is that I am not fulfilling my duty to the nature the law requires it to be fulfilled. I will give you a very common example. Now, law requires that every seller of an alcohol shop has to verify, when a person comes to purchase alcohol, his age. So, whenever he suspects that a person who has come to purchase alcohol looks like a person below 18 years of age, he should ask for some identification from that person about his age. If that person fails to provide that identification, he should not sell. But in case if he sells, now what he is doing? He is violating his legal duty. Okay? So, this is violation of legal duty, this is a wrongful act. Now, when these wrongful acts are a constituent of torts, these wrongful acts are constituents of torts when they give rise to an injury to a legal right with consequential legal damage. So, when is this wrongful act or act which is complained as wrongful or prejudicial, commits violation of legal right? And also important is that just not violation of legal right is enough. The violation of legal right should also lead to consequential legal damage. Now, what is not important is that the damage may not be actual, the damage may not be actual. Now, what is actual and what is not actual damage, I will come to it. So, therefore, there has to be a wrongful act which causes injury to somebody's legal right, and this injury leads to what you call legal damage, right. Now, I will show this transaction through an illustration. I said everybody has a right that his reputation is protected. In the previous lecture, we saw in the functional definition, whether given by Winfield or by the Supreme Court in Jayalakshmi Salt case, very clearly says that to prevent injury to self, to reputation, to property, the law creates this branch of branch or discipline of law called torts. So, therefore, torts establishes a legal right on everybody of enjoying his reputation. So, when I have a legal right to enjoy my reputation, everybody in the world, because tort is a right in rem, everybody in the world has a duty to not damage my reputation. So, duty in rem. So, as I have a right in rem to enjoy my reputation, everybody has a duty in rem. Now, X, in violation of that duty of rem, published in a newspaper saying that Dr. Anirban Chakravarti is a big thief. Now, the act of publishing by X is a wrongful act. Why? Because it impairs my legal right of enjoying my reputation. So, the test that I had said earlier, the test of prejudicially affected. So, I am prejudicially affected. Okay? Now, this prejudicially affected is what? My legal right, and I can therefore say that this will cause some damage. Now, it is not necessary that that damage that is caused is something very high economically or very nominal. Now, if you remember, in the recently a movie was made, Oh My God 2, where the theme was that a small boy was rusticated from the school for some sexual act, and the father of the boy went to file a defamatory suit against the boy, against the school and other authorities, saying the action of rustication is wrong, and also this has caused severe damage to their reputation. And what he sought from the court? He did not sought a huge amount of monetary compensation. He sought my son should be readmitted to the school. Second, my son should be allowed to continue his education. And the third, there should be a nominal damage recognizing your wrong. So, 101 rupees, which will be again also not taken by the plaintiff, it will be deposited to the fund of the temple. It was in a background of Ujjain. So, the Lord Shiva's temple, it will be given to the fund of the donation of the Lord Shiva temple. So, this is what. Now, always not damage that is claimed has to be very real or very big. There can be nominal damage also. So, therefore, but you have to show that some damage has happened, some legal consequence or some damage has happened, and the damage is actually actual damage is however not essential, it can be nominal damage also, right. Now, this principle has led to these two important maxims in law of torts, which are foundation, which is called injuria sine damno and damno sine injuriae. Now, what is injuria sine damno? Injury to legal right without any actual big damage. Now, the first case which this principle was upheld very clearly lays down or a very nice illustration to understand what is meant by real or actual damage and what is meant by not real or actual damage. Now, in this case what happened was that in an election, public election, a person was a voter and he decided to give his vote in support of a candidate. But on the election day he was wrongfully denied to enter into the election booth. He was not allowed. And it is a very old case, Ashby versus White, one of the foundation cases of law of tort. Now, he was not allowed and there were justifications given that he had failed to show adequate proof, he has lost his voter list, etc., which all were found to be not appropriate. Now, the last point that was argued by the defendant is, even if we say whatever we have done is wrong, even if we agree that he had a legal right to vote which we have wrongfully not allowed him to exercise, but how does it matter? Because he has suffered no damage, because the person he wanted to give his vote, the person he wanted to cast, which is clearly documented in various public speech or even the affidavits that he submitted, has won the election. So, therefore, if that person has won the election, there is no wrong or there is no loss that has happened to him. So, therefore, what is the problem? Even if we have acted in a wrongful manner and as have injured his legal right, court said no, damage is not necessary. Damage may be consequential in real form, a nominal damage is enough, but injury is the most important aspect in law of torts. So, injuria sine damno. So, injury has to be there, but injury to legal right has to be there, damage may or may not be there. Another example of injuria sine damno is that a action will lie against a banker having sufficient funds in hand belonging to the customer for refusing to honour his cheque, although the customer did not thereby sustain any actual loss or damage. So, I have tendered a cheque to the bank and it is supposed to be deposited to my wife's account. Now, I have sufficient money, but the bank denied to pass the cheque because there was an error on part of the clerk saying that he does not have funds, and the cheque was returned and the amount was not transferred to my wife's account. Now, of course, my wife did not took me to court or filed a 138 case. The wife may not actually have suffered any loss because that money that I was transferring was for the purchase of some ornament which she could have done even a year later also, does not make a difference. But when I have money and the bank employee negligence led to the bank's wrongful denial of transaction of my cheque and return, is violation of my legal right. So, whether damage has occurred or not does not matter, I am entitled to compensation in torts. Now, compensation may be 1 rupees also, but that recognition that there is an injury caused to me is the most important thing that the plaintiff will get in this case, that there is a wrongful act on the part of the defendant. But on the other hand, when we see the second contesting maxim, damnam sine injuriae, there lies that damage has happened but injury has not happened. So, damage does not make any difference. Damage with injury or injury without damage makes difference. Now, in this case, the first case which led to the formation of this principle, the Gloucestershire Grammar School case, where one person was employed in school X, suddenly one fine day resigned from his job in X and started a rival school within 200 meters of the X school, and because he was a very popular teacher in X school, 50% of the students of X school went and joined his school. Now X school filed a case saying that he knew our database, he was our employee, he allured our students when he was our employee in our back. So all this, and the most important thing, because of his school we have suffered so much loss. 50% of our students have now left our school and taken admission in school. So 50% students fee is a loss. So therefore we are entitled to compensation. Court asked this question, simply tell me that person starting a school in front of you, what legal right violation he has done? What violation of legal right he has done to you? If you show me, I will grant you relief. Now obviously that school could not show any legal rights violation because he resigned, then he opened, and anyone can open. There is no legal restriction. So that gave rise to this principle, damnum sine injuria. So damage is not important, injury is important. So when there is a damage without injury, law of torts does not apply. There is one more very interesting aspect, that duty has to be legal and not moral or any other form. We have already discussed that. I will give you an interesting example. A person is walking in the middle of the night on a highway. Suddenly he sees that there is a 3 months baby somebody has left, and the baby is crying at the top of its voice. It is already 11 or 12:30 at night. Dogs are surrounding that baby. There is a very chilly weather. So by all possibilities the baby will not survive more than another half an hour if she or he is left in that condition and not rescued. Now this person initially stopped, thought to rescue, but then suddenly a second thought came to his mind. Now if I rescue, then this question will come, whose baby, whether I have stolen. So he decided not to rescue and left the baby and escaped from the scene. Next morning it was found that the baby has died. One person saw this man was identified, and question is whether he has committed any wrong. The answer is straight no. Why? Yes, morally his action is unjustifiable. It was a morally wrongful act. By seeing a 3 months baby crying in the middle of the road, not rescuing, it is a moral wrong, but not a legal wrong. There is no legal wrong in that. So legal right, unless is there cannot be a legal wrong, and if there is no legal wrong, there cannot be a law action in torts. However, just legal right and legal wrong will not be enough. What is also necessary is that the wrongful act must give rise to a legal remedy in the form of an action for damage. So that is the third important aspect. The wrongful act must be of such nature as to give rise to a legal remedy in the form of an action for damage. Now there is a Latin maxim which has been usually used by courts in these kind of circumstances, which is called ube jus ibe remedium, that there is no wrong without remedy. So no wrong can happen if there is no remedy. Ube jus ibe remedium. So in Ashby vs. White's case, which I referred just some time back with reference to the injuria sine damno maxim, has held, and I quote, if a man has a right, he must of necessity have a means to vindicate and maintain it, and a remedy if he is injured in the exercise or enjoyment of it, And indeed, it is a vain thing to imagine a right without a remedy. Want of right and want of remedy are reciprocal. So, what the court says that if a man has a right, then vindication of that right is essential, and if somebody is unlawfully or illegally encroached that right, then a remedy must be provided by the court. Without such vindication right or right for remedy, the very right becomes absolutely unnecessary or useless to him. So, therefore, right without effective enjoyment and right of enforcement, if that right is not allowed to be enjoyment, is an essential integral part of the very right. So, therefore, in law of torts, a right has to be of such nature, an action has to be of such nature, a wrongful act which must give rise to some damage. Now, in Leighton versus Cooper, where a person had injured his neighbor by his car when she was on her lawn, now the action for relief was under law of trespass. However, here in order to show a law of trespass, there has to be a direct action, but there was no direct action on the part of the plaintiff. It was a it was somehow unincidentally it happened, but the unincidental act could have been regarded as a negligent act because there was some negligence on the part of the plaintiff. However, negligence cannot apply here because negligence is a time bound period within which the case has to be sued. In this case, the plaintiff failed to sue within that time bound, so negligence was not available. So, he used the theory of trespass, but trespass could not be used here. Now, he said that because negligence I am losing for limitation and you are not granting me trespass, then I am remediless. So, how are you going to then enforce my right and the wrong that has suffered to me? Now, court said that where a man has a right, the law should provide a remedy. An absence of remedy in evidence, but is not conclusive that no right exists. However, when the remedy of trespass is not available because the direct infringement has not happened, then in that case pushing to trespass just because negligence wrong cannot be granted because of limitation of time frame does not justify. So, ultimately court refused, but this is meaning of the term that wrongful act must be associated with a legal remedy in the form of an actionable damage. Now, the next important question is mental element. Now, crime requires mens rea. Tort does not usually require mens rea, majority of torts, mental elements. But in some cases, it does require some element of higher gravity, where you show that this is high, more more serious nature or reckless. So, recklessness may not always include intentional, wrongful, that kind of a nature of malice, but recklessness in itself can aggravate the seriousness of a law of tort action. Let me give you an example. A road which is usually very highly crowded during the whole part of day and especially in the evening, clearly says that you cannot drive in this road more than 40 km speed, and the driver in that road driving at 80 km speed caused death to 3 people and serious injury to 3 more persons. And in another case, a road which is usually a highway not used by many people, where the speed limit is 100 km and the driver driving at 180 km again causes death. Now, in 100 not 80 km, 110 km causes death. Now, both are serious, but in the first case it is a case of reckless. Now, why it is case of reckless? The answer is that attention of an ordinary prudent individual to possibility that this act is capable of causing a kind of serious harmful consequence is usually more. When you drive in a busy, heavily crowded road at a 60 km/h, it is all possibility you know that you will meet accident, and still, without any kind of awareness of the consequence, you drive. And what is your act then? Reckless. But in a highway which is 100 km, you drive 110 km, it may cause death, but it is not reckless per se, right. So, slight risk or those harm consequences occurring which are not so ordinarily prudent man would not be usually afraid of taking is not a reckless act. But what amounts to a reckless act? A reckless act is doing something where an attention of an ordinary prudent individual to a possibility that this act was capable of causing a kind of serious harmful consequence, yet ignoring that he continues to continue that act is a reckless act. So, that very sheer reckless behavior. So, usually mental element in torts are not there, but when an act is reckless, then it is given a more aggravated form. Now, coming to the last issue, can there be a single theory or principle of tort, or tort is divided? Now, there are two very important scholars who have pointed out different views here. One is Salmond. Now, Salmond has generally denied any fundamental general theory of liability of torts. Salmond said torts are subjects of different baskets. So, depending on the factual aspect, you have to put the particular tort into that basket. So, that gave rise to what is called pigeonhole theory. So, these small pigeonholes are there which are different torts: negligence, nuisance, trespass, false imprisonment, malicious prosecution, and depending on the factual situation which leads to that, you will put that into that pigeon. So, there is no one single theory of torts. Each tort varies, each has its own fundamental ingredients, and that is why he says that a subject should not be called tort, which earlier some people used to refer, but it should be called law of torts. Now, this definition of Salmond of law of tort was to some extent disagreed by Winfield. Now, Winfield said that if we see over the progression of time and if we see over the progression of period, we understand that there is a commonality of certain points which join these actions into one branch of law. Now, he said that if we do not have a commonality, then how can we distinguish this is law of tort, this is contract, this is law of tort, this is quasi contract, this is law of tort, this is crime. If each one of them is different, then we have to say negligence versus crime, nuisance versus crime, trespass versus contract. That does not happen. Na? In the previous lecture we saw law of tort versus quasi contract. So, there must have been some unifying factor. So, there is a general fundamental principle of liability, and this general fundamental principle of liability has allowed this discipline to develop in its independent form and as an independent separate branch as called law of tort. However, this Winfield's theory has not been accepted in England and in many other countries, whereas in America, the American courts have accepted that there is a general fundamental theory of law of tort, and there are several critiques of that. But more or less in India we have also ascribed to the view that it is law of torts and not law of tort. So, that giving the definition or the nomenclature as law of torts allows us the flexibility of say that torts as a basket will increase. However, to total extent there are differences also. Let us not go into that details, but basically the subject, therefore, this is the reason is called law of torts. So, I now summarize and conclude this particular second lecture that the law of tort as a subject constitutes of three very important aspects. One is that there has to be a wrongful act. Second, this wrongful act has to cause some legal injury, and the legal injury should have a consequential damage that can be awarded. Mental element is not usually an integral part of law of tort. However, in certain cases, if the act of the defendant is such reckless or careless, then it aggravates the nature of the tort, and more serious punishment or more serious compensation, not punishment, more serious compensation can be granted. So, with these words I finish my second lecture for this course, and thank you very much and hope to see you in the next lecture.